Utah child support for an adult disabled child, when support can continue after age 18. Utah child support usually does not last forever. In most cases, current support ends when the child turns 18 or graduates from high school during the child's normal and expected year of graduation, whichever occurs later. But Utah law recognizes an important exception. A son or daughter of any age may still qualify as a child for child support purposes if he or she is incapacitated from earning a living and lacks sufficient means of self-support. That can mean child support continues after age 18, after high school graduation, and in some cases for many years. But this is not automatic. A diagnosis alone is not enough. A disability label alone is not enough. The real questions are functional and financial. Can the adult child work? Can he or she live independently? What care, supervision, housing, medical treatment, transportation, therapy, or daily living support does he or she actually need? What resources are already available? What unmet need remains? The starting point is Utah Code Section 81-6-101, which defines child for child support purposes. That definition includes a son or daughter of any age who is incapacitated from earning a living and, even if able to contribute some resources, is not able to support himself or herself by his or her own means. That is the key. The issue is not merely whether the adult child has a medical condition. The issue is whether the condition leaves the adult child unable to earn a living and unable to meet his or her own support needs. Helpful evidence may include medical records, psychological evaluations, vocational assessments, school records, IEPs, guardianship filings, Social Security determinations, DSPD eligibility records, work history, failed employment attempts, care plans, therapy records, and testimony from people who provide regular care. The evidence should show not just what the adult child has been diagnosed with, but what the adult child can and cannot do. Once the court determines that the adult son or daughter still qualifies as a child for support purposes, the next question is how much support should be ordered. Utah Code Section 81-6-202 requires the court to use Utah's child support guidelines. The court does not simply invent a number because the adult child is disabled, nor does the court automatically continue the same amount that applied when the child was a minor. The court may also consider the adult child's ability to earn and benefits received by or on behalf of the adult child, including SSI, SSDI, disabled adult child benefits, Medicaid, funded services, waiver services, housing assistance, employment income, and other resources where applicable. But benefits do not automatically eliminate child support. SSI may help, but usually does not cover everything. Medicaid may cover some medical services, but not necessarily housing, supervision, transportation, respite care, uncovered therapies, or other daily needs. The right question is not, does the adult child receive benefits? The right question is, after earning ability and benefits are considered, what unmet support need remains, and how should that be allocated between the parents? These cases require careful proof. Utah law can require support for an adult son or daughter who remains incapacitated from earning a living and unable to self-support. But the court should base that decision on evidence, not assumptions, labels, or sympathy alone.